Good afternoon, everyone. Welcome to our first August webinar, What You Need to Know About Contract Disputes. My name is Alina Gilbert, and I'll be presenting today. And honestly, can you believe we're already in August? I mean, before you know it, it'll be 2026. Where does the time go? All right. Well, let's go ahead and start with some of our housekeeping items. And by the way, if you think this is hilarious, like I did, we are all dating ourselves on this one. So, for those of you who have not attended one of our webinars before, the bulk of your screen should be this awesome Billy Idol meme. And then me, the presenter, should be, I'm off to the side on the left. On the right side, you should see a little icon that says chat. This is what you're going to use when you have questions as we go through the materials. And I am saving all questions for the end because I want to make sure we have enough time to get through all the materials we have and then save the questions at the end. And we should have time. So hopefully we can get to all the questions. If you are having any audio or video issues, there is a little button at the bottom that says audio or video issues. You can press on that. It'll take you through a few steps and hopefully it will take care of the problem. You will get 1 CMCA credit for attending. You need to stay on, for the entire webinar, but you will get 1 CMCA. It's automatically generated and it will be email blasted to you. You should probably have it today, if not today, tomorrow. If you haven't seen it in a couple of days, then reach out to us and let us know and we'll make sure another one gets sent. Now, when you do get your email, cannot stress this enough, these certificates, they kind of disappear after 30 days. And what you need to do is download the picture and save it or save the email somewhere, or you need to basically keep a copy of it. So if you don't, it's going to disappear and then you're going to be looking for it and it won't be there. So just make sure you save the certificate in your computer. As a reminder, we are recording the presentation. It's going to be on our YouTube channel. So if you know someone who really wanted to attend and couldn't, they will be able to view this webinar on the YouTube channel. They just won't be able to get the CMCA credit for it. And the last thing I have to say is there is going to be, as always, a survey at the end of the webinar. So if you have some time and the inclination, we certainly appreciate any and all feedback we get. And it helps us improve our classes and make them better for you next year. So thanks in advance to all of you who completed. And now, without further ado, let us talk about what a contract is. I think inherently we all know what a contract is, but it's also important to note that a contract does have some legal requirements for it to be considered a legal contract. So what is that? Well, it has to be a transaction between 2 or more individuals. I can't have a contract with myself and then sue myself for not complying with it. So the individuals have to be competent to contract. And what does that mean? I mean, it's pretty much what it sounds like. You need to be of sound mind and understanding and kind of know what you're getting into. The contract has to create mutual obligations on both parties. So both parties are required to do something. And that could be what? Pay, perform work, whatever the contract says. So there is going to be basically an obligation on both sides where I perform work and you pay me money, or I get you some sort of a product and you pay me money, or however it's structured. And then there's a reciprocal right to demand performance. In other words, there is a right if someone breaches for the other party to say, hey, you need to do this. Okay. And essentially those are major components of a contract. There's obviously a whole bunch of other components, but these are kind of the big ones that we all need to remember. We don't, one-sided contracts are basically, I promise to do something and all you do is accept it. That's not going to be considered a legal contract because you don't have any obligations. It's a one-sided kind of obligation, and under the law, it wouldn't be considered a contract. So just FYI. All right. I'm talking while you read the Dilbert. Okay. So let's talk a little bit about why contracts go bad. I'm sure you have all experienced contracts that have gone awry, and you could probably tell me so many different stories that are both funny and sad at the same time. So let's talk about what I've seen and what we typically see as some of the major reasons why contracts go bad. So first, there's of course the breach, where someone doesn't perform in accordance with what the contract requires. And that could mean a lot of different things. So I only have a couple of examples. So, you performed the work, but you damaged my property while you were doing it. Or you performed the work, but it took you like 8 months instead of 1 month. So, when someone doesn't comply with their end of the deal, obviously you're going to have the contract go sour because the other side is like, hey, you need to do this. We agreed to this. Something that's less tangible is people have different standards, okay? Why? Well, because a lot of things are, I would say, based on kind of your standards, right? What you are used to, what you think things should be, and if they're not defined, then the standard in my mind may not equate with the standard in the contractor's mind. So, for example, how many of you have had contractors where they do the work and you look at it and you're like, this sucks, this is horrible, this isn't what I wanted, it's not what we asked for, or where they do something and the board doesn't think it was done right, or we reach out to the contractor and we don't get a response for 5 days, and we think that is absolutely inappropriate. And so those are our standards, right? But the contractor, in their mind, maybe responding after a week is perfectly normal in their brains. Or maybe what they did was what they had laid out in the contract, but the association maybe made some assumptions that it shouldn't have made, or didn't properly read through the contract as far as what is going to happen. But sometimes we just have different standards. What I think is good client servicing may not be what you think is good client servicing, right? So when you have different standards on the two sides, and it's whatever it is isn't clearly spelled out in the contract itself, that's when you are ripe for disputes, because the board's not going to be happy because their standards haven't been met, and the contractor doesn't understand what the issue is because they've done things to their standard. But we've never explained what those standards are. Assumptions. We just mentioned assumptions. They're not spelled out. Just some examples. Who gets the permits? Is it the contractor or the association? Who pays for the permits? Are they part of the contract price? Or is that something that the contractor charges back to the association? How does this work? There's always assumptions made on that. And if it's not spelled out, there is going to be a dispute. Also, there's generally a presumption that the contractor is going to be using brand new materials when they're building things or repairing or replacing things. But that's an assumption on the board's part. It's not necessarily a requirement if that's not spelled out in the contract itself. So it's very difficult to think of all your assumptions, but we want to try and address as many of them as we can. And that's really the reason why contracts get so long when you get the attorneys involved, because we're trying to think of anything and everything that can go wrong or that can be misinterpreted, and we're trying to set it all on paper so that there is no opportunity for things to go awry, which is why you see our contracts as being fairly lengthy, because we just want to make sure everything's in there to protect the association. But these are not things that most people think of unless they're attorneys. So they won't automatically be in there. What else? Verbal agreements. Ever been in a situation where the contractor says, oh, sure, no problem. Of course, we're going to take care of everything before we ask for your final payment. No problem. We'll take care of all the punch list items. You won't have to pay a final payment until then. Well, if that's not written in the contract, I cannot tell you how many times I've had contractors basically demand final payment before they fix the punch list items. And the association says, but you told us. No, I didn't. If it's not in the contract, if it's not in writing, it doesn't exist. So never ever rely on verbal representations from contractors, because I'm not saying they all lie, but I'm just saying if they're not in writing, they do not exist as part of the contract. So be careful with any verbal representations you get. Poorly defined terms. These are the ambiguities, the things that are subject to our own standards. Okay, contractor will repair any damage caused within a reasonable time. What is that? Is it 1 day? Is it 10 days? Is it a year? What the association believes is a reasonable time is very likely not what the contractor believes is a reasonable time. So maybe if you're going to use that kind of a term, you want to define it. Or instead, just use very specific language. Contractor will make repairs within 10 days of notification of damage, or something like that. Something that is very black and white, something that isn't subject to interpretation by others. Same thing, like substantial compliance, full and final completion. That you see terms like that thrown out all the time in contracts. I like to take them out or define them, because all they do is they create a cause for the parties to have a conflict, because we have different definitions of what this means. So try to avoid those kinds of terms in the contract, or if they have to be in there, let's define them. External factors. So sometimes things happen that are really outside the association's control and outside the contractor's control. So strikes, heavy rains for weeks on end, shortage of materials, and ultimately the association is at the point where we're like, we don't care, we want our work done. And the contractor says, well, I can't do the work because I don't have any materials to do it with. And what do we do in that case? What happens? So with those types of things, we do see some disputes pop up, and those are also things that we want to make sure are addressed in the contract. Because if they're not addressed, guess what? We're just going to fight over it, and we're going to go back and forth, and in the end, nothing is going to happen. All right. Comedy relief, just for a second. All right, so these are all the things that could lead to contract disputes. But as I said, there's probably a million more things out there that you guys have experienced firsthand that are just nutty and crazy. And in hindsight, you're like, oh, darn, we should have done this before. We should have addressed this in the contract. But it was too late once we got to that point. So the next question is, well, how do we protect our community from contract disputes, right? We want everything to go smoothly. We don't want the association to be out of pocket money for stuff it doesn't want or stuff it's not happy with. How do we protect the association from having to deal with this? And, on the contractor's end, of course, they want to protect themselves. So just know that any contract you get presented from a contractor, the original version of it is going to be aimed at protecting the contractor, not at protecting the association. So let's look at provisions that we really want to make sure are in all our contracts so that we can have the adequate protection that we need to avoid conflicts as the progress goes forward. So timing of the performance. When is it going to start? When is it going to finish? It doesn't need to be like a specific date. It can be, the work will start within 1 week after full execution of the contract. Be something like that. And will be completed within 3 weeks, 4 weeks. Again, not exact date. And the reason we want that is because otherwise, if the progress is taking far longer than what the board thinks it should, it really doesn't have a leg to stand on to claim there's a breach of contract, because we don't have anything in the contract saying it'll be performed within a certain amount of time. I had this happen a few years back. There was an association that they were replacing their balconies. It was a condominium association. Well, they didn't have legal review the contract, and they signed it as is, and there was no specific timing. Well, so the project starts 8 months later. They've only replaced like 2 balconies, and there's about 50 in the community. So the board is livid. They want to cancel this contract. They want to terminate this contract based on breach, except that there's no breach. So it just makes things that much more difficult to resolve, so to speak. So make sure you have timing, specific scope of work, and plans and specifications. I was actually reviewing a contract this morning, and in it, it talked about the scope of work, and it referenced an initial bid. Except we don't know what the bid says, and it wasn't attached. So make sure if the work itself is not spelled out to a T in the contract, that the scope of work is at least attached to the contract as an exhibit, which makes it part of the document. Because you want some really specific description of what's going to happen, where it's going to happen, how it's going to happen. If are there any exclusions to, like, we're going to replace the roofs in all the buildings? Does that include the clubhouse, or is it just the residential buildings? We want it as close to, like, including everything as possible, because we don't want to leave anything up to chance, and we don't want to leave anything up to anyone's assumptions. So the scope of work needs to be there. And granted, you're not a roofer, you're not an engineer, neither am I. But if you're looking at something and it feels weird, or you have questions, but wait a minute, what about this? What about that? Make sure that you pose those questions to the contractor before you sign anything, because once you sign it, it's done. Okay? Even if you feel like they're stupid questions, ask them anyway, because you may need some clarifications added to this document. Definitions. This kind of goes to those ambiguous provisions. You always want to make sure that terms that could be interpreted in different ways are defined if they're going to be in the contract. So for example, we like to use the word full and final completion of the project for final payment. That is a term of art. And when I put that into a contract, I always define it, and I say, this is what it includes. It includes you finished all the work. It includes a site inspection. It includes the association accepting the work and writing. It includes completion of all the punch list items. It includes all the lien waivers. I mean, and you make it very clear as to what full and final completion is, so that the association is not forced to issue payment before all of these terms have come to fruition. So again, there's lots of provisions that we see in contracts that just aren't clear, okay? Make sure they're defined if they're going to be used. Change orders is another big one. Usually I don't see good provisions for change orders in contracts as they are originally presented. There might be a mention of it, but then somewhere along the lines, you're going to see language that says, that if there is a change in the work, that the board and the contractor are going to use their best efforts to negotiate an updated price. That's not good enough. Okay, it's just not. What we wanted to say is that any changes to the work, or the materials, anything that's not named in the contract, must be evidenced by a written change order. It has to be signed by both parties. And I always like to add a little tagline that says, hey, and if the contractor performs work or does any kind of upgrade without a signed written change order, they don't get compensated for it. We're not required to compensate them because they did it outside of we didn't give them permission to do it. So You're never going to see that kind of language in a contract from a contractor. That's something that requires us to demand that it be inserted in there. Okay, what else? Default remedies. What happens if someone defaults on the terms of the contract? And this works both ways. So for example, what happens if the contractor fails to timely perform the work? What happens if the association fails to timely pay the contractor? This provision, I mean, it really protects both parties. What are the remedies? Do we immediately get to cancel the contract? Do we provide the contractor with notice and give them some amount of time to remedy the breach? Because remember, if we say we're going to immediately terminate the contract, most contractors don't go for that. But also, if they do go for it, they're going to demand that it be the same for the association. So if the association misses the payment 1 month, then the contractor gets to immediately terminate the contract. And what happens if we just, oops, it slipped through the cracks, we missed the payment? It happens to the best of us, okay? It just happens. And so do we really want to put the association in a position where all of a sudden there's an immediate termination of the contract? Typically, you're also going to see some damages with that, because the contractor is going to say, oh, well, if we have to terminate the contract, you owe us damages, and vice versa as well. So kind of think that through. Think about what the default remedy should be. Can we stop payment? Can we withhold payment? Can we have our own contractor, different contractor come in and do repairs and then take it out of the total amount? I mean, there's a lot of options out there depending on, first of all, the type of contract we're dealing with and kind of what the board's temperament is and who the contractor is. So you really want to make sure all of that gets addressed. And the next one is payment. This is, I always say, I cannot tell you how many times, but this is a really important provision, and it doesn't get the effort and the time that it needs in contracts. Generally, contractors will say, so, you know, payment is due this much on signing, this much maybe delivery of materials, this much when we're halfway done, this much when we have substantially finished the work, and then you can retain 10% until whatever. And it's not clearly spelled out. We don't know, for example, what substantial completion is. We don't know what's 50%. What does that mean? It's not defined. And what you really want is to have something very specific spelled out. At the time, within 10 days of signing contract, this much is due, specific dollar amount. When materials are delivered to the site and contractor starts working, this much. When buildings 1 through 5 are finished being re-roofed, this much to the contract. And then kind of final payment due upon, like I said, full and final completion, which is defined as pretty much everything else, right? So we want to have very, very clear provisions with respect to the payment. You want to know how much, you want exact dollar amounts. Don't let it say like 50%. Do a dollar amount and then maybe in parentheses put 50%. When is it due? Are there any conditions precedent to us paying? Does every installment that they ask for, do we want lien waivers for that work? Let me talk about lien waivers for 2 quick seconds, because I don't think most people or even contractors know what that is, or they're trying to pull the wool over your eyes. So a lien waiver basically says, I am a subcontractor, I'm a material supplier, I have been paid for all the work I've done or all the materials I've supplied to this point, if we're not done with the project, to this point. And I waive any rights I have to record a mechanics lien for this portion of the work. That would be a waiver, a mechanics lien waiver. What I see contractors providing and associations accepting is a document that says, I am subcontractor. I agree not to record a mechanics lien against the property if I get paid. If I get paid. So basically what they're saying is, I haven't gotten paid yet, and I can record a lien should I not get paid, which is what the law says anyway. So that doesn't give us anything. That is not them acknowledging that the contractor has paid them, because the concern is we have situations where contractors take the money and split, and they don't pay their subs. Now the subs under Colorado law can come in and record mechanics liens on our property because our property benefited from the work. So lien waivers are extremely important, and we want to make sure they are lien waivers, not, oh, we promise we won't record a lien if we get paid. That's not a lien waiver. That's nothing. All right. Okay. Let's talk about some other provisions. And you see, there's a lot of stuff. So you can understand when you look at all this various stuff, why contracts are lengthy when you get the attorneys involved. I'll tell you a funny story. I love my funny stories. I was teaching, this is a while, this is pre-COVID when we were doing live classes. I was teaching a class on contracts. And there was a woman sitting there. I can't remember who she was. I don't know if she was a manager or a board member, but she was sitting there and she basically said to me, well, that's just silly to waste money on having attorneys review the contract. And I said, really? And she said, yeah, we already know what needs to be in there. We can do it ourselves. We don't need to waste money on you guys to do it. I was like, okay, we'll just agree to disagree on that one. But as I started going through all the various provisions and things that contracts need to have, I kind of saw her mouth kind of opening wider, 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 and wider. Because she, all of a sudden, it hit her that it's not as easy as she thought it was. So at any rate, I just want you to know that, drafting contracts really is a legal document, and please don't skimp on your attorney fees for this, because it's going to cost you far more down the road to fix something than if you just have your attorneys review the contract. I'm done. Okay. All right. Other provisions we want. Indemnification. This is a provision that basically says if the association gets sued based on something that the contractor did, okay? So contractor damages a unit window, owner of the unit's really upset, they want association to fix it, association wants contractor to fix it, and ultimately the homeowner is sick of waiting and they sue the association. So now we are sued because of something this contractor did. Indemnification provision says contractor will pay for our legal fees to defend this case, and so that we are made whole as an association, so we're not spending money out of our own pockets. Now, how will the contractor do that? The contractor will do that through their insurance policy. And so kind of the other part of the coin, the flip side of this coin, is we also want to make sure there is some good language in the contracts in which the contractor is basically agreeing to have the appropriate insurance that is required under the law. But also what you want to add is we as the association, we want to be an additional insured under that policy. But in addition to that, if we just say an additional insured, then we'll be an additional insured, but the problem will be we can't file claims with the contractor's insurance because we're just an additional insured. If we want the ability to actually file the claim without having to go to the contractor asking them to file the claim, which they could say no to, we need to demand that we are a certificate holder on the insurance policy. If you're a certificate holder, contractor gives you a copy of the certificate, you are now entitled to actually contact insurance because you're a certificate holder, and to submit claims without having to wait for the contractor to do it. So that's really the best way and only way to do that. Contract termination, when does the contract terminate? Sure, it terminates when we finish the job, but can it terminate earlier for other reasons, like breach, like you're doing a horrible job and we don't want to work with you anymore? Is there an opportunity there to terminate the contract early? And if so, let's make sure we can terminate it without any kind of a penalty. Because a lot of times will see contracts that say, yes, you can terminate this early at any time for any reason, but you as damages, you as liquidated damages, HOA pays us the remainder of the contract. So we, we've terminated the contract, we don't get the work, but we got to pay for the whole thing. Ridiculous. We don't need that language in there. Assignment. So assignment is, let's say you have a contract with ABC Landscaper. ABC Landscaper decides to sell to XYZ Landscape Company, and it assigns their contracts to XYZ. So XYZ now takes over the responsibility of the contract. Take it one step further. Let's say the association has used XYZ Landscape Company in the past and hated them. And now all of a sudden they get stuck with XYZ again. We don't want that to happen. So with the assignment, we want to make sure there's a provision that says nobody assigns the contract without the other party's written authorization. Because you don't want to have your association stuck using a contractor that you've worked with before and never wanted to work with again. Under Colorado common law, if you don't have the verbiage, then technically contracts can be assigned, and there's nothing we can do about it. Notice, throughout your contracts, you're going to see references to providing notice to the contractor, notice to the association. There's always provisions in there like notice of breach, notice of increased costs. I mean, I don't know, it could be a million different things with notices. We want to make it very clear how notice is to be delivered, where it's to be delivered, and how it is set. Does it have to be in writing? Yeah, we want it in writing. How can we deliver it? Is email okay? Does it have to go by snail mail? Does it have to go by certified mail? And where? What's the address? What's the email address? Where does it go? You absolutely need this language so that we don't have to then bicker later on whether or not proper notice was given. Attorney fees. This one is, I always get on a soapbox for this one. And most people say, oh, well, of course you're going to get on a soapbox, Alina, you want to get paid. And I say to them, I do want to get paid, and I get paid regardless. The attorney fees provision allows the association to recoup what it paid me if there's a legal action and the association wins. Colorado law says that unless otherwise agreed to in writing, and there any kind of a dispute or most disputes, each party is going to be responsible for their own attorney fees. Doesn't matter who wins or who loses. So if you ever want the ability to get your legal fees back after, if you have to sue a contractor and then you win, the only way you're going to even be able to ask for them is if you have this language in your contract. Venue is where will legal action be appropriate. We want it in the county where the association is located. You would think that would be pretty standard. However, when you're doing business with contractors who are nationally spread out, most of them will provide that venue is actually appropriate in whatever state and county that the main office is in. So, that we definitely want to make sure that venue is going to be where the association is at. Warranty. How long is the warranty? When does it kick in? What we want to make sure of is that We really want the warranty to kick in only after the punch list items are done. Most contracts will have the warranty kicking in at like substantial completion, which means it starts to tick earlier and it gets done earlier. And we don't want that. We want everything to be fully completed and accepted before the warranty starts, okay? Because that's the fair time when it should start. So again, this is important, and we always want to pay attention to that provision and see when it starts, see how long the warranty is. And keep in mind, there's two kinds of warranties, okay? There's a manufacturer's warranty, and then there's the warranty on the actual work that was performed. So the contractor is giving you a warranty on their labor. They performed it properly, nothing's going to go wrong for a certain amount of time, whether it's 1 year, 3 years, 5 years. That's the warranty on the labor. The warranty on the actual components that were used, like the roofing materials, the sub-roofing, whatever it is, the underlayment, that comes from the manufacturer, and typically your contractors will have reference to it in their warranty section, but it's just important to understand that that's a different warranty, and typically it's a lot longer than the workmanship warranty, and it comes from the manufacturer, not actually the contractor guaranteeing it. All right. Amendments. How do we modify this contract? We want to make sure that both parties sign off in writing on any modifications. Use of subcontractors. A lot of associations want to know and want to have identified any subcontractors that are being used for work. The reason is that, again, if you've had some bad experiences with certain contractors, you want to make sure they're not being used as subs on your project. So a lot of associations will want to add provisions to their contract saying that if the contractor is using subcontractors, before they can use them, they must be disclosed in writing to the board, and the board has a certain amount of time to veto any contractors or something along those lines if there is a concern with identifying those subcontractors. Dispute resolution. What are the steps we take if we do have a dispute? Most contracts will require binding arbitration. I like to take those out. The reason is that binding arbitration, first of all, is not cheaper than litigation. It's actually more expensive. And the reason is that, you know, when you go to court, you got the judge, you don't pay the judge. The judge is getting paid through the taxes. When you go to arbitration, the arbiter gets paid a lot of money, and it's split between the two parties. So you're going to be stuck not only paying your attorney, but you're going to be stuck paying this arbiter. The other thing about arbitration is that you're essentially giving up your right to appeal the decision. What the arbiter decides is full, final, you're done. With a court proceeding, there's always the option to appeal if it is completely wrong, unfair, and the board wants to challenge it. So arbitration is not something that attorneys typically recommend. Contractors seem to like it because there are a lot of arbiters out there that are former contractors and that side with contractors, and that works for them. It does not work for us. So if you're seeing arbitration requirements, I would not agree to that. I usually take that out. Right to withhold payment. How many of your boards, or how many of you board members out there, when the contractor does something and we're not happy, we say, don't issue payment on that. Don't pay them. We're not going to sign the check. Well, that happens a lot. And I would say 90% of those, that's a breach of contract. Because unless your contract specifically says that one of your remedies is the right to withhold payment, there's no right to withhold payment. It's not a statutory right. It's not really a common law right. It's not a right at all. So that needs to be spelled out in your contract. So yes, if you don't have this provision, can you be screwed by having a contractor that does a horrible job and you still have to pay them and then try to get your money back? Yes, that you could get screwed like that. So this is why we want to include the right to withhold payment in our contracts. We also want a provision that says just because I paid you doesn't mean I'm releasing you from liability. Sometimes we pay under duress, right? Sometimes you don't want to deal with going to court or with them threatening to sue you. So you're going to issue the payment and then the board's going to decide whether or not it wants to go after the contractor for some sort of a breach. So we don't want the contractor to say, hi, you paid me, therefore by paying me, you have essentially accepted what I've done. So we want to make it clear just because we pay a contractor, that does not mean that we have accepted that work or we think the work is up to par. All right. All right, I think enough about contract terms. I think we've all contract termed out. Let's talk about red flags. And these are just like a few very minor, well, a few major ones, but I mean, there's a lot of different red flags. But for our purposes, be careful if you see a contract that's like 1 or 2 pages, especially when we're talking about a large scale project. You just saw the provisions that we want to make sure are in there to protect the association. There's no way that a 1 or 2 page document can contain all of that. It just can't. It's not possible. I mean, unless you use microscopic print, in which case we go to the last little thing on this slide and that says very small print. That's also a red flag. So either one of those are good. When I get contract reviews, if the manager has sent me a contract that's 1 page or 2 pages, I pretty much write a new contract that has all the provisions. And then what I do is I take that old proposed contract, I attach it as an exhibit for the scope of work only. And then we use the contract that I've drafted because, like I said, a 2-page document is not going to contain all the stuff we need. You also have a lot of times where the association is provided with a contract, but there's blanks. Like maybe you haven't decided on the final price. Maybe you haven't decided on what the increments are. Maybe you haven't decided on whether the association wants to purchase additional services. So there's blanks. Don't ever, ever, ever sign a contract with blanks. Okay, once you sign it, it's up in the air. We don't know. And we don't know if somebody's going to go and fill it in. So make sure every single blank is filled in, even if it's something that just says not applicable. You don't want to leave any blanks. That is just trouble brewing. Management company, manager, board member are identified in the contract as the contracting party. This happens more often than you would think. Contractors are not necessarily savvy in who they're contracting with. If they send a bid to the management company, a lot of times they just assume that's who they're contracting with. So they'll put the management company name in the contract as the contracting party. That's not good. It's not the management company. That's contracting. If they put an individual manager, that's not good because that's not the contracting party. Not even a board member. What you want is the legal name of the association, the corporate name. Where do you find that? It's the name you see in the articles of incorporation that you have on file for your association. That is the only legal name, okay? So we want to make sure that's the contracting party. Otherwise, someone might be on the hook for paying this contract who isn't the association and who isn't getting the benefit necessarily of this work. So be careful. All right, and we already said very small print. If you got to get a magnifying glass out for it, red flag should be going off. And either you can reach out to the contractor and say, hey, can you send me a copy with larger print here because I can't see this, or you send it to the attorney and have the attorney get his or her magnifying glass out. We all have magnifying glasses. I will tell you that the attorneys in this office, and I'm sure other HOA firms have magnifying glasses. We use them not just for contracts, we use them to look at certain, like sometimes plat maps that are teeny weeny print. So we do have them. All right. Now I want to talk about what not to do as an association. Refuse to pay contractor. I know we've gone over this, but I can't say it enough. Don't just not pay the contractor because you're unhappy with them. You want to make sure, if you're going to stop payment, that the contract actually authorizes you to do that. So you got to have a provision that says you are entitled to stop payment. Otherwise, if there's a breach, you really need to be looking at your provisions on breach, termination, etc., and see what remedies are provided in the contract. Immediately terminate contract. Again, same as refusing to pay. Don't assume you have the right to immediately terminate it. If you immediately terminate it or you stop payment and you have no right to do that in the contract, now you have become the one who has breached, and now the contractor may have a claim against you and may impose late fees, interest, whatever else the contract says. So don't make assumptions as to what remedies you have without looking at the contract or having your attorney look at the contract, which brings me to the next point, which is don't sign a contract without having legal counsel review it, especially if over $5,000. I don't know. I'm okay if it's $7,500. You sign it without having an attorney review. Ultimately, you know, how much does a contract review cost? Depends on the contract. Could be $1,000, could be $1,500. I mean, somewhere in that ballpark. If it's a really complicated, long contract, it could be $2,000, $2,500. I don't know. But generally speaking, is it worth that money in legal fees? Well, if you got a contract that's, I would say $5K or more, but a lot of folks say $10K or more, you're definitely investing in that contract and you need to have it reviewed because, like I said, you stand to lose a lot more than just the contract amount. You could stand to lose legal fees that you have to pay out of your own pocket and not be able to recoup. Which brings me to a point I really want to make sure everyone understands and knows. Many boards have the opinion that, you know what, it's okay if we breach the contract and the contractor sues us because, you know what, we'll submit a claim to our liability carrier and they'll defend us and it's fine, we're okay. Please, please, please knock that idea out of your heads and your board members' heads right away, because insurance policies, liability policies, first of all, a lot of them have exclusions for contract breach claims. In other words, if the association is sued based on an alleged breach of contract, you get nothing because it's excluded from coverage. Some policies will actually cover the defense costs associated with defending the association on a contract breach claim. What you're never going to get is an insurance company covering the association if it loses a contract breach claim for the damages. Why? Insurance companies are not in the business of paying out association or anyone else's contracts. That's not what they're there for. So even if they pay for your defense, which is by no means a given, they're not going to pay out any damages. So if you've got a liquidated damages clause that says you got to make, you got to pay the full contract price because you terminated early and you lose, and that's awarded against the association, insurance ain't going to cover that. If you get attorney fees awarded against you because you lose, highly doubt that insurance will cover that. So what do you need to do to be safe? First and foremost, I would recommend everyone reach out to their insurance representative and find out what, if any, coverage you have right now that will protect the association from lawsuits based on contract breach. You might have coverage for your legal fees. If you do, that's amazing, but you may not. And you also want to find out whether or not, if you lose and attorney fees are awarded against you, whether or not that's something that insurance would pay for. Most likely they will not, but they definitely will not pay for the actual damages awarded that you owe under the contract. That is just not going to happen. Okay, so be careful with that, and don't assume that insurance has got your back on these, because it doesn't. Finally, what not to do: don't sign a contract without reading it. I know a lot of boards say, well, you know, our attorney reviewed it, so we can sign it. No, you need to read it. Here's why: because your attorney, when we review contracts, we are looking at it from a legal perspective of, is there enough protection for the association? But we don't know whether, you know, payment being due 30 days from the invoice date is something that works for you. We don't know how your financials work. We don't know if the board is okay with paying for the electricity to be used by the contractor. Those are things that only the board would know. We can point it out, but we don't know how you function internally. So the boards need to look at their contracts. They need to make sure that the terms, not the legal pieces, but the terms with respect to protocol, that those all work for them and work with the way their finances are being handled and their expectations. Never sign a contract without reading it. I'll let you read that. And I'm going to start going through questions because we are done and we have 9 minutes left. And I am going to try. All right, I'm going to go down to the bottom. Let's see. Is there a statute of limitations for a contract? Contract breach claims in Colorado are 2 years, and it's 2 years from when work was last performed. Okay, so if it's been more than 2 years and neither party has filed a lawsuit, then guess what? Nobody can file the lawsuit now. Ooh, okay, this one's been answered. If a contractor provides us with a contract and there are just a few things that need to be addressed, can we have a separate contract to address those items rather than going through a lengthy contract rewrite? Yes, that is actually called an addendum, which is just an addition, a fancy legal term for saying it's an addition to the contract. And it's a separate document, but it references the contract, gets attached to the contract, and it modifies or supplements the contract. And it is signed by both parties to the contract. Okay, so that's what that would entail. That's a good question. If an association had a contract that said the second phase would be completed in October of 2024, and it was not due to contractor claiming weather acts of God, then said again in writing that the work would be completed in the spring of 2025 and it was not completed, then the association hires another contractor to complete the work. Basically, contractor accepted the work and then stated they could not get the correct product and the design now needs to be delayed due to unavailable products. Had it been completed prior to the materials being available, blah, 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 is there liability for the contractor? That's a lot of facts, and the answer is really it's going to depend. It's going to depend on a lot of things and a lot of facts. One little teeny grain of fact could change the whole analysis. So I can't tell you on this particular one. I would say reach out to the attorney for the association and have them review everything. They're going to need to review the contract. They're going to have to review all the communications between the association and the contractor and anything else, any other documentation that you have before they can really tell you whether or not there is a claim to be had and what the remedies would be for the association on that one. Sorry, I'm just looking through. Okay, let's see. If the board holds back payment, which is a breach of contract, can the contractor place a lien against the association? Yes. So contractors and subcontractors can record mechanics liens against the property that benefited from the work. So that could mean individual units. I've had situations where in a condominium complex, there was a re-roofing project, association didn't pay, or contractor failed to pay their subcontractors, and liens were recorded against every single unit under those roofs because they benefited from the roof replacement. And when that happens, it's obviously not very pretty, because what happens is you have a homeowner who's trying to sell or they're trying to refi, and all of a sudden this thing pops up on their title work and they can't do it. And so now the association has to step in, and typically we have to put a whole bunch of money in escrow to allow the closing, but it may not close because the buyer may be like, oh, I don't want to be living in this community because they have all sorts of mechanics liens issued. So it's definitely not a pretty situation. We don't want our boards or our associations in that kind of a situation, because it just does not turn out very well. When you state that all contracts over $7,500 should be reviewed by legal, does that include all T&M proposals from a contractor such as a grounds contractor? If it's a proposal the board is planning on signing, I would recommend they have legal review it before they sign off. Sometimes proposals are used interchangeably with contracts by contractors, and although they may say proposal and you sign it, then you may be signing a contract and not just a proposal. So yes, I would have those reviewed as well. Vendor was contacted to replace treads on stairs. Turns out there was rot in the stringers. So now a permit is required, and commercial contractor, okay, so now a permit is required, and the commercial contractor, because it is a multiplex condominium, vendor is not, sorry, I'm having a hard time reading this one. Does this invalidate the contract, essentially? Not necessarily. I think this is one of those situations where perhaps your contract is not complete because it doesn't speak to this. And so now you're going to have a dispute, but it just really depends on what the contract says. Again, what the history here is, what all the facts are. I just couldn't tell you just, based on that. All right. I'm making sure I didn't miss anyone. Oh, found one. Hold on 1 second. Okay. Most trash haulers and pool management contractors will not sign an HOA contract. They insist on their contract. How do we deal with those situations? You're right. There are some companies that will not budge on their contracts, and we kind of will tell the client that up front. And it's really up to the client. Either they take the contract as is without any protections, or they decide they're going to find a contractor who will work with them, and they're not going to give their business to this particular contractor who isn't willing to make any changes. So it really just depends on what your board is, what kind of risks your board is willing to take. It's easy for me to sit here and say, well, they just need to find a new contractor. It's easier said than done. I get it. So I think it just depends on where the board is at any given minute. All right. We are out of time, and I think I got to pretty much all the questions. So Thanks, everyone. Thanks for joining us, and we will see you next time. Have a great afternoon.